go. Good evening, everybody. Welcome to the City of Lewiston's Board of Appeals meeting for Wednesday, May 22nd, 2024. Shelley, would you help me with a roll call vote? Roll call, please.
Absolutely, Mr. Chair. Jeffrey Goslin.
Present.
Daniel Dubé.
Present.
Paula Maselli.
Here.
Bernard McAllister.
Here.
Melanie Dorn.
Here.
David Projansky.
Here.
Paul Colasante.
Here.
And Matthew Agron.
Here.
For the purposes of clarification, in regards to the last meeting, Mr. Agron, our associate member, was a voting member at the last meeting of April 29th. He will continue to be a voting member this evening, as an alternate, as well as Mr. Colasante. Daniel Dubé is here, but he was not present the night of the prior meeting, so he did view the video, is my understanding. Is that correct, Mr. Dubé?
Yes, I viewed the video.
But since, due to his absence, he will not participate as a voting member this evening, so. Okay. We have one item of new business, and this is subsequent to the meeting of April 29, 2024. We're having a meeting to hear a petition for the appeal submitted by 36 Shore Rd LLC for an administrative appeal regarding the property at 36 Shore Road. The board is meeting this evening to review a draft decision and adopt a written decision related to a findings of fact, a notice of decision and findings of fact and conclusions of law. Just want to provide clarification to our board. This is an opportunity to provide further context of the board's decision, if we so choose, with findings of fact. So we're going to hear from the city's council, and we'll also hear from Mr. Bond as well as to regarding what your comments are regarding this, and then we'll have a couple of options to decide upon and see which direction we go. That being said, I'm looking for a representative from the City of Lewis to provide their input as to why we should be looking to add additional comment or regarding the notice of decision and finding of facts.
Sure. Thank you, Mr. Chair. It's my understanding and practice in boards of appeals that it's often common for the board to make a decision and to revisit and adopt findings of fact and conclusions of law. My understanding is Attorney Brunetti prepared such conclusions, and that's what's before you today. When I reviewed them, I had some additional comments and changes that I believe are consistent with the board's decision on April 29th. In the cover letter that I included with the documents, with the two copies, I included one copy of a clean copy of the staff's proposed decision, and then a red line copy to show the differences with Attorney Brunetti's. The petitioner's attorney made clear that he saw a number of procedural errors, and that I strongly disagree. But out of respect for that and an abundance of caution, I'm suggesting that the board reconsider its action on April 29th. The statute provides that a decision may be reconsidered for 45 days. There's a second sentence that says the exact first sentence is, the board may reconsider any decision reached under this section within 45 days of its prior decision, period. A request to the board to reconsider a decision must be filed within 10 days of the decision that is to be reconsidered. So this is not a formal request to reconsider that the city staff could do as a party and that the board would then have to act upon. This is a suggestion that the board may want to consider. With that, thank you.
Thank you very much. Does anyone on the board have any questions for Attorney Carey or any representative from the City of Lewiston? If not, Mr. Bond, do you have anything you'd like to add regarding this?
Mr. Chairman, shall I sit here so my...
Wherever you'd like.
Yes, members of the board, it's an odd turn of events today because 36 Shore Rd LLC will be arguing that on April 29th, you did have jurisdiction to determine if the December 1 determination letter was an appealable decision of a code enforcement official. But this afternoon, I argue that you do not have jurisdiction to hear whatever is happening tonight. As a brief overview before I get into the details, the reasons that you do not have jurisdiction is as follows. And this includes the ability to reconsider your prior decision. The Board of Appeals concluded its hearing of my client's appeal on April 29th. Full stop. The board did not table the appeal. The board did not continue the appeal. The board did not suspend the appeal. The board voted on and concluded the appeal. Furthermore, the board did not lawfully issue its findings of law, in fact, within 7 days, by either delivering its notice of decision in hand or by certified mail to the required parties. That was a required element. That is an element of due process that serves to protect the parties in this case. No decision means no reconsideration of a decision that did not exist. You reached a verbal conclusion, but there was no writing, no mailing, no certified letters to the required parties. Furthermore, no request for reconsideration can be timely made at this point. The 10 days are over. Even your own code says that a request for reconsideration has to be made at the meeting, which did not take place, or at the immediate next meeting, regularly scheduled meeting of the board. That was May 1st. That did not happen. Under the board's policies and procedures, the last date upon which a motion to reconsider could have been made was May 1st, 2024, 21 days ago. Moreover, the meeting notice did not identify the purpose of the meeting as a hearing for a reconsideration request, which is required by the code. Also, the meeting notice was posted 2 days late under Section 2-164. Also, the meeting notice was posted without a copy of the appellant's appeals being included in the packet. I am sure that you have noted, I won't go there. I think that's, the rest of my remarks will come in due course if you choose to reconsider. That's all I have for now.
Thank you, Mr. Bond. I had just one question. You mentioned the date of May 1st. The meeting was on the 29th. Why May 1st is the date?
Because, let me find the exact language.
2 days. The meeting was on April 29th. You mentioned that the date was May 1st. I just don't understand how that's 10 days.
Reconsideration of items. This is in your Board of Appeals, Division 2 Board of Appeals. This is 2-163, Organization of Rules, Reconsideration of Items. When an item is voted on by the board, which took place on April 29th, it shall be in order for any member who voted on the prevailing side to move reconsideration thereof during the same meeting or at the immediate next regularly scheduled board meeting, but not afterwards. And the regularly scheduled meetings are the first and third Wednesday of every month.
Okay.
The first Wednesday was the first.
I'm sorry. I was just trying to understand the first as a date when it was 2 days after, but it was a special meeting. Gotcha. Thank you.
You're welcome.
Any other questions of Mr. Bond before I let him sit down? Or
Go back to my seat.
no additional, so before I'm going to ask Mr. Brunetti to provide some instruction to the board. We have a couple of items to consider this evening. First, we have to consider or determine that the context of the motion and the vote that we took on April 29th was sufficient and speaks for itself. If that's the case, if that's the preference of the board, I'll be looking for a motion and then a subsequent second, and then we'll have a vote. The board can also choose to move to adopt the proposed findings of fact as presented, as edited, or as presented originally, or as edited, or something in between. The third item is to make a motion to reconsider the original appeal by one of the, and for that to occur, There are obviously some considerations that Mr. Bond has put forth, but we also, for that to happen, it would need to be one of those of you who have voted in the affirmative. So anybody but Mr. Agrin can make that motion
In
for number
addition,
3.
5 members would need to consider consent to that reconsideration.
We would get a motion, and then we would have to have a vote.
With 5 affirmative
With
votes.
5 affirmative votes at that point, should we get to that point. So again, it's one of 3 items that I'll be looking for a motion for. So I will defer to the board. Does anybody have any additional questions for either staff or the applicant at the present time? Mr. Brunetti, do you have anything you'd like to add, providing any context?
No, just a little bit. The board has jurisdiction to amend its decisions within 45 days of the issuance of the decision. Mr. Bond raises some issues of procedural fairness and standing that he's free to raise, and whether or not those become part of an appeal of this decision, that's up to him. For the board's purposes, you are entitled, if you wish, to either reconsider with 5 votes per the rules, or move to adopt the proposed findings of fact, and we can deliberate those as at the board's initiative, which is you have the right to make the record whole if there is question about what you voted on the night of
Attorney Brunetti,
29th. Sir?
Could I ask you to just move your speaker so I can hear you?
Sorry, I thought you were cutting me off.
I was not, sir.
Then I apologize to you.
None needed.
If within the 45 days, which we are within, you wish to adopt proposed findings of fact because you find it necessary to supplement the record to provide additional context as to the reasons why you voted the way you did, you have the right to do so. That does not mean you must do that. The motion you made on the 29th of April included specific facts in it. So to some degree, it is self-explanatory. However, for purposes of this board and the city staff and the petitioner for future petitions that or issues that may be raised, it may behoove this board to issue additional findings to guide it as to how it wants petitions presented or how it wants the facts regarding standing to be presented to this board before it makes a decision. So that is your choice to make. Whether that happens as, so if you decide that, that further deliberation needs to occur, you may either move to adopt the proposed findings of fact, or you have the authority to move to reconsider the vote of the 29th. Both of those would allow you to have additional deliberation. I just want to add that that in the proposals that I submitted, and that was really supposed to be a rough draft as a starting point for discussions. Attorney Carey flushed out some of those issues in his red line, although he does make some more specific findings of fact. It is not, you are not under any obligation to weigh either of those one way or another. Mr. Bond is welcome to, should be welcome to present his interpretation of the findings as well, if you wish to deliberate.
Thank you, Mr. Brunetti.
Mr. Chair, if I may.
Yes, Mr. Carey?
Before I do, Chris, what's the citation again to the ordinance that you said, section 2 what?
Well, it's reconsideration of items. I'd have to take my packet apart to find out.
But it's the policies and procedures, not the ordinance, correct?
Oh, it's the, oh, wait a minute, maybe it is.
Yeah, the ordinance doesn't speak to reconsideration.
Okay, that's policies and procedures, I'm sorry.
So I was trying to take notes to the objections that were raised. First, the basic position that there's no jurisdiction here, and in fact, that there's no decision because the notice of hearing was issued late, and it was 1 day late. So there's no decision would mean that it's a denial of the appeal because it's not deemed to be passed. And so where there's not a passage of an appeal, it is deemed to be denied. So just as a logical matter, that doesn't make sense that the 1 day failure to issue a notice of hearing means there's no decision. Second, the statute doesn't speak to written decision. The statute has three ways it describes decision: reconsideration, but it describes any decision, and it describes the original decision. So when there is a question about appeal, it is 45 days from the date of the original decision. There are the other references to any decision. Let me give you the specific language. The board may reconsider any decision reached under this section within 45 days. So as you interpret the statute, you need to understand what's the difference between any and original, and it's not reconsideration because that has a separate set of appeal language. So the statute provides for exactly this practice of a vote at a meeting for which there was a record, notice of decision being issued for that vote, and then coming afterwards with a written decision for consideration of findings of fact for the board's decision. So then let's come to the argument about, so statute is clear, the ordinance doesn't speak to it. So the policies and procedures under the rules, first of all, policies and procedures can't change the statute, and so it's got to be kind of consistent within the statute. The policies and procedures, so the upshot is the policies and procedures regarding reconsideration of items, so doesn't make sense. It is not clear. And let me explain why. No motion to reconsider a vote taken at a previous meeting shall be in order unless the item to that effect is scheduled on the agenda for such meeting, or unless 5 members to consent to such reconsideration. In addition, notice must be provided to the public. So the board makes a motion, staff must provide notice to the public for that motion, and yet it starts that it shall only be in order for the person who voted on the prevailing side to move reconsideration thereof during the same meeting. So one of the 5 of you who voted for it, 6 of you voted for it, could have moved reconsideration, and then that would apply. Or at the immediate next regularly scheduled board meeting, but not afterwards. It couldn't then be up for notice if there was a motion there. That's the first way in which the statute isn't clear. Second, it doesn't capture requests for reconsideration. That is clear that's the first way in which the policies and procedures aren't clear. Second, it doesn't capture requests for reconsideration, which the statute is clear are in order from a party within 10 days. And then the third way is it speaks to 3 different time periods, and I'm going to go through them in a second. But there's a fourth. And the fourth is a specially called meeting, which is what this is. So and I'm going to kind of go through this slowly. When an item is voted on by the board, it shall be in order for any member who voted on the prevailing side to move reconsideration thereof. So here's the language where there's 3 different discussions. During the same meeting, 1, or at the immediate next regularly scheduled board meeting, 2, but not afterwards. There hasn't been a regularly scheduled board meeting since the 429 meeting. So we are still in the period between the immediate next regularly scheduled board meeting and the vote of the hearing. What about that situation? the policy isn't clear, and so it doesn't address this situation here. And so you're in a situation where the policies and procedures are ambiguous as to this situation, and yet you have a statute that is clear. Finally, it was argued that notice must be provided to the public, and because the reconsideration wasn't provided on the notice, that's improper. Again, policies and procedures and ordinance cannot change the statute. The board has the authority within 45 days to move reconsideration. But a party doesn't after 10. So when you're looking to come to a meeting where reconsideration may be there, it is improper for the notice to discuss reconsideration because there is no motion for that, because none of the parties know what any of you will do, let alone 5 of you. And so this is there's a law court opinion that says there's no apparent ambiguity in the statute. As to the 10-day restriction, as the 10-day restriction is not present in the first sentence, a board is not subject to it. If the legislature had intended to limit the time within which the board could start the reconsideration, it could easily have done so. As there is no ambiguity in the plain meaning, its ordinary meaning governs. Reconsideration by the board is subject to a 45-day limit. So that's the statute, that's what the law court has said. Now you need to deal with the policies and procedures, which are ambiguous. Don't consider this particular type of a meeting, and so it's properly before you. If you choose not to do reconsider, staff's position, and I believe that you can consider either of the draft, the proposed findings of fact and conclusions of law, so long as you decide that is what you decided. Thank you.
So just for clarification to the board, and Mr. Carey's opinion in response to Mr. Bond was that the board does have the ability. That's his opinion. Mr. Bond's opinion obviously is that we do not. But do you have another comment, Mr.
Well, I
Bond?
was going to comment, yes. Basically,
Yeah, I'm sorry. Oh, sorry.
Attorney Carey seems to argue that because the statute works for you, you should take that route. Municipalities routinely pass statutes and or ordinances that are more strict than what the state provides for. That's a well-established legal principle, I believe. So the fact that Lewiston has a stricter limit on when decisions can be reconsidered is not inconsistent at all. Apparently, the state is more liberal than Lewiston is. I think you're constrained by the more strict restrictions. And I don't know, quite frankly, I could not understand what Attorney Carey was saying. It sounds very unambiguous to me. When an item is voted on by the board, which happened, it shall be in order for any member who voted on the prevailing side to move reconsideration thereof during the same meeting or at the immediate next regularly scheduled board meeting, but not afterwards. That is not ambiguous. The parties are not moving for reconsideration here. They did not move for reconsideration. This would be a motion for reconsideration from the board, and the time has gone for that. You don't have the power to do it.
Thank you, Mr. Bond. Now, again, what I'd like to do is provide both parties have talked about the point of reconsideration. None of it matters unless we decide we want to do that. For that being, I'm going to try and provide just clarification again of the 3 options we're going to have. I'm going to then ask for a motion starting with the first option, and then we either make a decision on that, or we don't, or we move to the second, and then subsequently would be the third option, which would be to consider reconsideration. So the first option is to determine that our motion and the vote of our meeting on April 29th was sufficient, speaks for itself, and we're not looking to add anything more, any findings of facts or anything further to that. The second item would be to adopt either of the 2 drafts, or we could add additional language to any of the drafts to make sure that our language is clear as to our decision on that same meeting on April 29th. And if neither one of those two things are something that the board would like to do or has its preference, we would move to the third, which would be, I'd be looking for one of those who voted in the affirmative to make a motion to reconsider. Those are the three items. So for the first, I'm going to be looking, do I have a motion to determine that the contents of the original motion and vote was sufficient, speaks for itself, and we are not looking to add any additional information or findings of fact for that evening of April 29th? I do not hear a motion. I'm going to ask for, do I have a motion to adopt proposed findings of fact that we have presented in front of us?
I make a motion that we adopt the motion of facts from our meeting on the 29th.
Mr. Chairman,
Yes, sir.
if before this motion is made or considered, and I hate to use a strong word, I demand.
You have
to be heard.
I'm sorry,
I demand to be heard, sir.
regarding the contents of the motions of finding of facts?
Absolutely, yes.
I would expect that you would.
Thank you.
So, let's start with getting a motion on the table to find out if we will have any edits to that memo, okay, sir? So, may I ask, Paul, for clarification of your motion, are you talking about the edited version?
portion.
Okay. So there again, so for the board purposes, we have a motion to adopt the findings of fact as edited by Attorney Carey. There is Mr. Bond, do you have the edited version in your pile with the red lines? With the red line or the,
I
okay.
do have the edited version.
I just want to make sure you have it, and then I'm gonna look for a second, and I'm gonna provide you your ability to provide any context if we need to make any edits to this motion.
Thank you.
I'll second it. We have a second by Matthew. Attorney Carey, I mean, any other comments from the board before I let Mr. Bond, because obviously we can make some edits to this, you know, as ourself, and listening to Mr. Bond, some of the comments he may have regarding this.
So, just a point of order.
May I have a clarification, Attorney Bond, before you go? I'm not going to make any argument. I just want to make sure I'm clear of what the motion is that's on.
Motion was to accept, the motion is to adopt the proposed finding of facts as edited, as edited, Mr. Carey, from, you know, which I'm using the red line version. I know you provided a clean copy. The red line version just was
Okay.
providing me some guidance. There isn't whether I use the red line version or the one that's not. Mr. Bond has some comments he would like to make. The board will hear those comments regarding edits to the finding of fact, so we can make a decision as to what would be adopted, the board would look to adopt.
Thank you.
All right, Mr. Bond, you can come back up and provide us your comments to the,
First of all, Your Honor, Mr.
well,
Chairman.
now, Your Honor, I assure you.
You are finders of fact in law, not unlike a court. Now, I'm just a little confused. In what capacity is this motion being entertained? Is this a de facto motion for reconsideration?
No,
No.
So,
we are not considering a reconsideration at this point, or at least the
But-
motion is not.
but you're adopting a document that that you believe speaks for you, that you did not adopt before. In what capacity are you doing that? By what authority are you doing that?
It is my understanding, and it's this board's authority to provide clarification to the vote and the motion that we took that night and documented in the terms of finding of fact.
And is it your position, Mr. Chairman, that you could do that at any time?
Excuse me, the board isn't a witness or making argument.
Duly noted, sir.
So it is,
My question stands.
excuse me, Attorney Bond. So it is improper to ask questions, and I object to a question to the board. You can make any argument that is properly before it. The board is not a witness here, and no board member is a witness or respond.
I'm not turning to the board as a fact witness, Attorney Carey. I'm asking about a point of procedure.
You're not asking about procedure. You're making argument in the form of question.
Bond, the way I'm going to interpret this is the board received this package Friday, first time we reviewed it. All right, the board we made a determination that of whether or not this is pertinent and valid to be included. We have 45 days to do so. So I gave the board the opportunity to make a motion to just leave it as it is, or look to adopt this as it should.
I understand.
That's where it said that in the document we have a draft that was here. We can make edits to this document, and you said you had some comments you would like to make towards that.
Well, the third option that you had was to vote for reconsideration.
Correct.
Which you haven't gotten to that yet. So my procedural question is, are you including in this motion a de facto
No.
motion to reconsider?
Was not my interpretation of the motion. This is not a motion
No.
for reconsideration.
Is purely a what we'd call a sua sponte decision to,
It is a point
Come
to
back
clarify.
here.
It is a point to clarify findings of fact. I reviewed the document. Outside of the document on the second page, which referred to the comments regarding this meeting, this document was an accurate reflection of the findings of fact surrounding the appeal request on April 29th.
it does strike me, Board Member Agron was the one person who voted against the motion, but now he's voting in favor of this motion.
I didn't, yes, that's correct.
And so
Just seconded it.
Yeah, he seconded the motion.
I think that's an affirmative vote, or affirmative, second, it's in favor.
In favor of putting the motion on the table for a vote. And the motion on the table for the vote is to accept the board, the findings of fact and evidence of, or conclusions of law.
My question is, may I present additional materials to you at this point?
We're not bringing up any additional materials regarding the original appeal. This is to conclude and provide additional document for,
Additional materials were presented to you in the form of Attorney Carey's document. That has pages of language in it that the board had not written before. And so I have new information that was not available on April 29th. I think it's relevant to the board's consideration, and I would like to present that information if the board is going to move ahead.
if we're going to consider reconsideration. At least I have not received a motion that we are reconsidering the motion. If we're not reconsidering the motion, we're not going to take in new additional information.
So,
Attorney Carey.
Mr. Chair, if I may, the question here, as I understand Attorney Bond, is a question of what is in the record. And he argued that there was pages of document that I provided and that he would like to have new information. And so I'm going to go to the statute that talks about what the record is. The transcript or tape recording of testimony, if such transcript or tape recording has been prepared by the board, and the exhibits, together with all papers and requests filed in the proceeding, constitute the public record, period. Next sentence, all decisions become part of the record. The statute anticipates exactly this situation, that there's a hearing, the record is closed, which the chair did, and then subsequent to that hearing and the closing of the record, there is a decision which is part of the record. You know, the first sentence ends with constitute the public record, period. All decisions become part of the record. This is entirely anticipated by the board, by the statute, as long as the board determines that what was in the decision is supported by the record. It is then become part of the record on appeal. Thank you, Mr. Chair.
My interpretation, for the purposes of the board, as I read through the document here, was this was an accurate representation of the decision made on April 29th as presented. And that's thus what has been proposed by Paula for consideration to be determined and added to the record. Did you have some suggested changes, Mr. Bond, to this document?
yes, I do, Mr.
You
Chairman.
don't, please, you don't have to call me Your Honor. I will assure you there again.
I have the right to talk. You're not going to allow me to submit documents, so I'll talk. I have before me, and I was prepared to give to you.
We have an editable document that can be made here too as well, so.
I just, as a threshold matter, if I can just interrupt, if we're using this red line, I just wanted to, there are a number of, as I'm tracking things so we can focus on the substantive changes. Mr. Carey provided Attorney Bond and myself with a summary of his changes, and one of them are basically my screw-ups in the initial draft of calling this board Zoning Board of Appeals and not the Board of Appeals, and changing ZBA to BOA, and changing Craig's title to Land Use Planner, and then I think I had a typo in Codes Enforcement.
Those changes come from Mr.
And
Bond.
those come from Mr. Carey. And changing italics to make clear that proposed conclusion language is not authority, convection to show code and statutory authority in italics in a few places, proposed language in italics, and to correct language regarding this specific appeal. I would suggest that it would be easier if those were, I think all of those, none of those have any substantive effect on the plan. Is there any objection for the purpose of this to making those changes?
Attorney Brunetti, I object to this meeting in its entirety.
Okay.
This meeting is unlawful. That is my client's position.
So, Mr. Chair, just as part of the discussion, perhaps, is maybe we poll the board informally if there's any problem with me accepting these red lines in the document.
I will, does anybody on the board regarding the changes that Attorney Brunetti mentioned regarding Board of Appeals, change of ZBA to BOA, Craig's title, the substantive clerical changes to make sure that this document is actual reflection? No comment, no additional comments?
Actually, as I was reading my packet and in my notes, the first thing I circled was, we are Board of Appeals, not the ZO. And so
Yeah,
I'm making all my notes going through the 29th of April's meeting. So
My-
then I'm thinking it was
my
repetition.
apologies.
No, that's okay. I'm just restating how I was reading this. When I got to this, it's like, oh, okay, here it is. They're done. Somebody found all these edits, because I was red penciling everything. And as I read this was exactly what the video, what we spoke, and what I take as minutes from the meeting of the 29th. So everything and why we denied it at that time was based on these facts. So
And
that's
what-
why I have made this motion.
Thank you, Paula.
And I believe that one of those facts was that Planner Tebow was not a code enforcement official, correct?
Correct at that time.
And through a FOIA request, my client did obtain Attorney Tebow's job description, which would certainly be a relevant document for this board to be aware of. And it does describe that even without being a code enforcement officer, he is in fact an inspector. And under Article 5, Section 4 of the code, that makes him a code enforcement official.
Mr. Bond, we're not taking new information as part of this, in this motion. It's not part of my,
I thought you just said that I'm free to talk.
I'm going to give you the option, yes, you're free to talk.
Well, I'm only able to talk about what Attorney
I'm trying to
Carey.
follow my rules of order of what I have in front of me, and we don't have this open for reconsideration, so I'm not bringing in new evidence. So I will give you 5 minutes to, if you would like to provide additional information that you'd like to put on the record, I'll let you do so.
I think you've already said that I cannot introduce any new evidence.
That's correct.
Am I able to comment on what Attorney Carey did draft?
Yes.
But I'm not able to say anything about that I disagree that would contradict what was,
If there's a change that you think that is inaccurate, that the board
well, it
can
says
substantiate and support who is in the room,
in Attorney Carey's draft on the second page, at the bottom of the second to last paragraph, Mr. Tebow testified that although he initially intended the December 1, 2023 letter to be appealable, he was not a certified code enforcement officer or inspector when issuing the letter. It's my understanding that he is a code enforcement officer.
Objection.
Again, I'm going to go by the place for that evening, our information with no information. If you've got something that's beyond that, I did not have that. The board did not have that that evening. The board made a determination that Mr. Tebow was not a code enforcement officer, hence.
And even if that decision was clearly erroneous, it does not bother this board?
It's not the point right now. We're not taking on additional new evidence, Mr. Bond.
I believe that this board wants to make the right decision, does it not?
Yes, it does. I'm
And
trying to follow procedural.
we're all here at great expense. Your time is valuable. My client's time is valuable. My time is valuable. And what I'm hearing from the board is that you do not want to hear anything else, even if it's true, correct?
That's not the case. Mr. Carey,
Would it be helpful to provide some background that is not part of the record?
If he may, then I
I
may.
can't be letting you have any additional
I'm-
information if I'm not letting Mr. Bond.
I'm not looking to put anything on the record, that's fine. There are some, there's, the key, well, understood.
I can't, I'm not letting
Absolutely,
any
Mr.
additional
Chair.
information, I don't care where it's coming from.
Absolutely, Mr. Chair, thank you.
So I understand, I'm going to bring it back, Mr. Bond, because I,
No, you're,
what else would you like to add?
well, what's in the record is the December 1 determination letter, correct?
December 1, yes, that information was presented as a piece of evidence
And-
the night of the 29th.
And it was determined by the board that it was not, did not articulate a requirement, decision, or determination or interpretation. So I just thought it would be good, because has everybody read this letter? This is the letter.
Objection.
I'll stop asking questions, Attorney Carey.
Thank you,
please.
Mr. Bond.
Non-conforming structure. Well, first of all, it begins, staff with the Department of Planning and Code have reviewed the proposal to move and expand the existing structure at 36 Shore Road, which is located within the rural agricultural district as well as both the shoreland zone and no-name pond conservation overlays. This property is subject to numerous zoning and land use requirements impacting any development that may occur. This is a technical document. Begins non-conforming structure. Upon visiting the property earlier this year, we confirmed the existence of a small shed, approximately 35 feet in size. However, having no record or permit of a structure in the property file or the assessor's card, we are unable to determine when the structure was built. Appendix A of the Code of Ordinances, Article 7, Performance Standards, Section 2, Shoreland Area Standards, subsection 8C1D, III states, all other non-conforming principal and accessory use structures that do not meet the water body, tributary, stream, or wetland setback requirements may be expanded or altered as follows, as long as other applicable standards of this ordinance are met and the expansion is not prohibited by subsection 8C1 and A, B, and C above. And for structures located less than 100 feet from the normal high water line of no-name pond, the maximum combined total footprint of all structures may not be expanded to an area greater than 1,500 square feet or 30% larger than the footprint that existed on January 1, 1989, whichever is greater. This lays out a possibility for legally non-conforming structures to be expanded in the shoreland zoning district, even if they do not meet the full required setback of 100 feet horizontal distance from the normal high water line of no-name pond. However, because there is no permit on file with the department, it is not possible to determine that the structure was in lawful existence at the time this ordinance or subsequent amendments took effect. The definition for non-conforming structure can be found in Article 7, Section 2, 4, Shoreland Zoning Definitions. Non-conforming structure, a structure which does not meet any one or more of the following dimensional requirements: setback, height, non-vegetated surfaces or footprint, but which is allowed solely because it was in lawful existence at the time of the ordinance or subsequent amendments took effect. If the applicant or property owner can provide a building permit granted for the structure, we can determine the date of construction and whether the structure is legally non-conforming. This building permit shall indicate the underlying use of the property. Staff can then work with the applicant in moving forward with their project. And then I go to the last paragraph. If a building permit which demonstrates that the structure was in lawful existence at the time the ordinance or subsequent amendments took effect cannot be provided, then any application to expand the existing structure will not be approved given the existing conditions. Now, Mr. Tebow describes this as a determination. That's his words. And if you go to the last,
The document was in the record, the document you're referencing was in the record the night of the 29th.
it further
Considered
ends,
by this board.
excuse me,
It was considered as part of the
this
evidence.
determination may be appealed through an administrative appeal process per Article 9, Section 3A1. Any application would be heard by the Board of Appeals. That's what we call an admission. That was the department's policy when they wrote this letter, which was written under the guidance and oversight of the director. And then now, this board has accepted from the department a complete reversal of that. No, it's not a determination letter, and no, it's not appealable. That's what the department is now asking you to sign off on. And you know from hearing that 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 is inaccurate by the department's own admission, Mr. Chairman.
The date that night was that Mr. Tebow is not a code enforcement officer. We debated it, we had the conversation, it was questioned, it was determined that he is not a code enforcement officer. That was the decision of the board that evening. As a result of that being, him not being a code enforcement officer, the decision and the letter that you referenced was not a decision and determination as a result of that.
You're incorrect, Mr. Chairman. Your determination was that he was not a code enforcement official. That included code enforcement officers and inspectors. He is an inspector. That's one of the primary duties he performs. And yet this board now is turning its back on that fact because it doesn't want to hear it. So be it. I strongly object.
I understand.
And I offer a proof. I don't submit these for the record. This is an offer of proof.
I'm not going to take
And I'm allowed to
it
do
to,
that.
you can give it to the city, you can give it to the city.
I'm giving it to you, sir.
You can leave it wherever you want.
I do.
So with that, we've not made any changes to the, we have not made any changes to the document that has been referenced, that has been edited by Mr. Carey, and Mr. Brunetti has accepted those edits. We have a motion by Paula, we have a second by Matthew, all right, regarding, again, a motion to adopt the proposed findings of fact as edited regarding the meeting of April 29th, 2024. That being said, Shelley, I would like to ask for a roll call vote. An affirmative vote, so a yay or a yes, is to accept and adopt the proposed findings of fact as presented and edited. So I'm looking for a roll call vote.
Okay. Mr. Chair,
Yes.
Daniel Dubé,
A non-voting member this evening.
Right.
Paula Maselli,
Yes.
Bernard McAllister,
Yes.
Melanie Dorn,
Yes.
David Projansky,
No.
Paul Colasante,
Yes.
and Matthew Agron.
While I disagreed with the decision that night, these are an accurate reflection of what was voted on that night, so I'll say yes.
So we have a 6-1 vote. That is the decision of the board to accept these finding of fact and submit it as part of the decision related to the decision made on
I have a question, a procedural question. What is the date of this vote?
Sorry, the date of what?
What is the date of this vote?
The date of this vote
Date
would
of
be,
the adoption is today.
the date of the adoption is today.
So the May 7th date on that document is erroneous?
Date of May 7th.
Yes, this will be dated today.
This will be dated, I guess, dated today.
So can I move to correct the record that that is not the correct date, that today is the correct date, May 22nd?
I would stipulate that the bottom, there's a line that says dated May 7th, should be May 22.
Any objections by the board for the date of May 22nd to be added to the document? No. So moved.
Mr. Chair.
And is this the final meeting on this?
So help me God, I hope so.
But you could come back.
I could if somebody, I guess if it happens in the right context of all the ordinances you mentioned earlier, I guess it could end up in front of us again. Okay, that being said, it's my understanding the only other item of business that we had from that evening was the reading of the minutes, which were not available. They will be available at the next meeting. Is that right, Shelley?
Correct.
So we have no other business for this evening. Can I have a motion to adjourn?
So moved.
So moved. Do we have a second? Seconded by Melanie. Anybody opposed? Thank you, everybody. See you next time.
We'll need,
Thank you, board.
Thank you.
we'll need signatures on this.
Yes. We need all
so-
my names added
Yeah,
with
I'm
our
gonna-
position title.
With some assistance from our technical team, I could probably,
So you need signatures from each of the members of the board to add to this document.
print it and for
We did
everyone.
adjourn, right?
We did
We
adjourn.
adjourn, but we need to
I
sign
don't know
off
if
on
Daniel
it.
is going to sign it because so.
No, he can't, he wasn't at the meeting. And
We're off, we off?
Took notes this time.
Not yet. You two can.
I had mine too, it's just added.